The fact and proud tradition that Canada has a citizens' army was first brought home to me in the 1970s when we went on a cross-country tour with our family. We would have our lunches in parks in various communities throughout Canada, and inevitably there would be a cenotaph in those parks. I'd go over and see on the cenotaph the same family names sacrificed their children for Canada in the First World War, in the Second World War, and sometimes in the Korean War. The next time it came through to me that there was a citizens' army was when I learned that there were two sons of friends of mine that had suffered grievous injuries during military service for Canada in Afghanistan. I also learned that they had been treated in a most unjust and inequitable manner by our government as a result of the new Veterans Charter. It soon became clear that there were thousands with legitimate grievances about their treatment under the new Veterans Charter, and that they had no access to justice to address their concerns. We decided to bring a lawsuit on a pro bono basis, with the Equitas Society formed to cover the extensive disbursements required in such litigation. Equitas was a suitable name for the society because what was sought was equality of treatment of veterans, no matter which conflict had caused their injury. Equality of treatment of veterans in comparison with other members of Canadian society who are awarded damages by the courts or compensation under other government programs. And equity, or justice and fairness, in the treatment of the young veterans. There was also recognized to be a need to enshrine the long-standing covenant of obligation to those that serve Canada in its military, so that this social covenant would be honored without fail and not be subject to the whims of bureaucrats or the competing demands of governments as times change. The obligation that is contained in the social covenant should not depend upon there being a corpse being driven down the highway of tears. The social covenant recognizes that when members of Canadian forces put on the uniform of their country, they make an extraordinary personal commitment to place their duty to country before their self-interest. A veteran has written a blank check made payable to the Government of Canada for an amount up to and including their life. There's no equivalent profession to that of service in the Canadian Forces. Those who serve in the armed forces may be ordered to hazard their lives in circumstances where death or serious injury is contemplated in military operational contingencies. In the First World War, our troops had to march to the trenches. In doing so, they passed the graves that were anticipated to be needed when they suffered the casualties that they indeed suffered. The social covenant is of paramount importance in a country that relies upon the voluntary recruitment of its youth to fill its military ranks. The social covenant was pledged by Canada's leaders in raising troops for World War I. Although Canada had existed since 1867, it became an independent nation in its own right as a result of the blood and sacrifice of those who served Canada in World War I. And the social covenant was reflected in the veterans legislation that followed World War I, in particular the Pension Act, which stood there to help veterans until it was abolished by the new Veterans Charter. While long recognized, Canada, unlike other Commonwealth countries, has not codified the social covenant. In the lawsuit, we ask the courts to do so by enforcing the social covenant through the constitutional principle of the honor of the Crown. The honor of the Crown principle has been invoked to enforce Canada's promises to its First Nations and Indigenous people. In the appeal in this case, the government argues that the honor of the Crown principle should only apply in that context, and that is, only apply to issues relating to Indigenous people, and that it does not apply to promises made to those serving Canada in its military. We do not agree with that argument. It is our view, whatever the court decides, that it would be desirable for Canada to legislate a standalone social covenant, as has been done in other Commonwealth countries. I have drafted a document called the Canadian Military Covenant which is to be found on the Equitas website. The social covenant has also been described as the sacred covenant and the social contract, which is a bit confusing. And I believe that the use of the word military differentiates the country's commitment to those in the unique situation of ultimate sacrifice from those to whom there are other national covenants of social significance. It is desirable to keep the military covenant concise. If one were to go through clause by clause in the military covenant document that's on the website, it is likely that no political leader could express disagreement with specific clauses. In addition, we have presented a draft military Veterans Bill of Rights, setting forth what we believe should be the core rights in the treatment of veterans by those involved in administering the programs. I and the Equitas Society welcome your comments, suggestions, or concerns about the litigation or about the draft military covenant and the military Veterans Bill of Rights documents. We continue the fight. The representative plaintiffs and their legal team and the Equitas Society will continue to press for justice, equality, and equity for veterans adversely affected by the new Veterans Charter through the litigation and advocacy generally. The exact path that will be taken to right this wrong will depend upon the decision of the courts, but we will continue the fight and we need your support. We thank Equitas and its supporters for making this campaign for justice possible. Thank you.